Hello and welcome. My name is Charles Buse and I'm a personal injury and wrongful death attorney. And today, we're going to be talking about a fairly common type of personal injury case. We're talking about slip and fall accidents in restaurants. Now, these types of cases are not only super embarrassing, but they can also lead to severe injuries and thousands of dollars in medical bills. Thus, these accidents can have serious legal implications. Now in this video, we're going to talk about the 5 most common types of slip and fall accidents in restaurants. We'll also talk about liability considerations and comparative negligence. So let's get right into it. And remember, if you find this content useful, please don't forget to smash like, share, and subscribe for more videos just like this one. So let's start out with the most common type of accident in this category: slipping on food. Ever thought a banana peel could be dangerous? Well, it's not just Mario Kart, people, because real life slip-ups happen all the time. Foods like sauces, mashed potatoes, or even butter, when left unattended on the floor, especially a hard floor, can lead to slip and fall accidents. And remember, it's not just the mess, but also the subsequent hazards that come with it. Thus, if someone drops something slippery on the floor, the policy at the restaurant should be to get a warning up ASAP and then get that mess cleaned up right away. That way, nobody gets hurt. Next up is our invisible enemy, liquids. It might be a spilled drink, a soup disaster, or simply a soapy water after a cleanup session. But this is a primary cause of slips in restaurants. Especially hazardous is the case of spilled ice because it melts into an almost invisible threat. The slushy combination of cold water and thin slices of ice can be particularly dangerous and slippery. So, beware and tread carefully around drink machines and ice makers. Leaving the confines of the restaurant, we move into the parking lot, a site commonly associated with trip and fall accidents. Unseen potholes or those overly polished parking lot lines can pose serious threats, particularly to elderly folks or those needing some assistance. These type of accidents may involve a defendant other than the restaurant because a lot of times parking lots are owned and maintained by a totally distinct business entity. Additionally, issues with maintenance could be due to a negligent maintenance company. So, identifying the proper defendant or defendants is critical in these types of cases. Now, it's not just what's on the ground, but also the ground itself that can lead to accidents. Uneven floors, shifting sidewalks, or pavement lips due to tree roots or ground settling are potential hazards that should not be overlooked. Now, how about lighting? Ever felt that a restaurant's ambiance was just a little too dim? Well, it's not just an attack on your ability to see your food, but low light can exaggerate existing hazards and even create new ones. So stairs in particular need proper illumination to prevent unnecessary accidents, especially where the stairs are uneven or improperly designed. Now, moving into the legal aspects, let's talk about liability. If you're a victim of a slip and fall accident in a restaurant, the question then arises: who is liable for that? Well, depending on where the accident happened and what caused the accident, different parties could be held responsible. So as we talked about in the parking lot example, there may be one or more defendants that are responsible for the parking lot or for maintaining the parking lot or for painting the lines on the parking lot. Additionally, if the person who slipped and fell was negligent, they may also be assigned a portion of fault, which would reduce their ultimate recovery under the comparative negligence rules, which we'll talk about next. So here's something for our Florida viewers. Did you know that in Florida, you can still file a lawsuit even if you're partially at fault for the accident? Now, this is known as modified comparative negligence laws, and this means you can still recover damages if you're less than 50% or half at fault. However, if you're more than 50% at fault, you can't recover anything. And if your fault is greater than 0 but less than 50%, your ultimate recovery would be reduced by your percentage of fault. Georgia and South Carolina have very similar modified comparative negligence laws. However, You should always make sure to understand your state laws when it comes to negligence, because they can vary from state to state. Well, that's all I have for you today. If you've been injured in a slip and fall accident because of a company's negligence or carelessness, please don't hesitate to reach out to us. We're happy to give you a free legal consultation and talk with you more about what happened to you. Now, you can schedule your free consultation by calling us at the number below in the video description, or you can look us up at www.carelessdriver.com. Now, we handle personal injury and wrongful death cases across South Carolina, Georgia, Florida, and North Carolina, and we're happy to help you however we can. Thank you so much for watching this video, and we'll see you next time.